Yes, thank you very much. We have a quorum and we've passed the appointed hour. The meeting of the Bills Committee on Product Eco-Responsibility Amendment Bill 2013 is now called to order. Agenda item number 1, confirmation of minutes. Of the minutes of the meeting held on the 8th of October. The Secretary has not received any proposed amendment. Well, there is no problem, I believe. So shall we confirm the minutes? Item 2, meeting with the officials. We'll continue to discuss the bill, but please invite the officials into the room. Good morning. Good morning. Please take your seats. The officials are Ms. Andrew Lai, DDEP, Mr. Samson Lai, ADEP, Ms. Selina Lau, Senior Government Counsel, and Ms. Libra Chang, SAO, EPD. We have just received several documents hot from the press. We just received it a moment ago. These are the issues which we have been discussing, and they are quite important legal issues. The paper before members are the proposed CSAs. Some are rather substantial and some are just conceptual. Mr. Wu Chi-wai has said that he may consider moving amendments, but up till now, Mr. Wu has not appeared. Maybe sometime later, we may have to call another meeting to study the amendments, the proposed amendments by members. All right. Please refer to matters arising, LS 17/1314. Or maybe invite the administration to speak first. Say, if a member wants to retain a dual-track arrangement leading to a different treatment, what will be the implications? The administration, please. Thank you, Chairman. Concerning the so-called dual-track proposal, we understand the member's starting point, but the administration has reservations basing on two reasons. First, on the point of law, we hope that in the business community there should be equal treatment for all. When we launched the phase 2 of the plastic bag levy, and when we expand the scope, we hope that all the businesses affected will be treated the same. If we want a dual system, or if we have a dual system, say basing on the size of shops and number of branches, and thereby giving different treatment, that may not have a firm legal basis and may subject to legal challenge. This is not practicable, therefore.
And we understand that at this stage, Mr. Wu Chi-wai has made a preliminary proposal. He hasn't actually submitted a specific CSA. So about the paper issued to electoral members yesterday, we only provided a preliminary view of the administration. And when and if members propose a CSA specifically on this point, we can then give a more in-depth response to the CSA proposed. And we also have policy consideration. as far as dual system is concerned. About the levy on plastic shopping bags, you may recall that in phase 1 we target franchise stores and stores with larger floor areas. And at the first stage, there is a clear policy intention that we'd like to apply the scope of the scheme to other retail outlets. As far as public acceptance is concerned and the operational feasibility, we think it's more desirable to implement the charge in 2 phases. And therefore, in the very first stage, we're already minded to extend the levy scheme. And in order to achieve this ultimate purpose, we would like to remind members of the public and retailers that under the levy scheme, all should be treated alike in a consistent manner. So as far as legal justification and policy considerations are concerned, if we are to implement the levy scheme, it should be treated in a consistent manner, and everybody should be equal before the law. Apart from L17/1314, I have also asked members to refer to administration's paper CB-1432/1314-01. I think it's starting from page 3 to page 5. Observations on Mr. Wu Chi-wai's preliminary proposal. Those paragraphs set out the administration's view. As said by Mr. Lai, there are policy considerations, and that's starting from paragraph 8 to paragraph 15. These paragraphs have to do with our discussion just now. Any supplement from our senior government counsel? Or legal advisor? You may begin. I understand, and I think members also do, that as far as policies are concerned, the government would try to abide by the principle of equality, but we have considerations because this is a bill that will be introduced in the laws of Hong Kong, and I'd like to seek an explanation and analysis from the administration. May I refer members to LS 17/1314. Earlier on, the paper was forwarded to the administration on the so-called dual system, or on different treatments for different retailers based on their different size, etc., or the number of chain stores, and expressed our concerned. And on Article 22 of the Hong Kong BOR and Article 25 of the Basic Law, together with the so-called test of difference treatment, we'd like the the difference in treatment. We'd like the administration to explain the legal basis for making the suggestion that such difference in treatment might be contravening the relevant provisions in the Hong Kong BOR and the Basic Law. And I won't go into details. The argument is set out in the paper. Apart from the relevant article in the Basic Law, Article 138 of the Basic Law has to do with the Hong Kong Bills of Rights Ordinance Cap 383, Article 22 and also Article 25 of the Basic Law. These are our discussion on constitutional issues. Any follow-up questions, Ms. Sit-Ho? Having heard the logic of the administration, I think at the Bills Committee meeting, we continue to hold diverse views. It's polarized. One is to extend the scope of the PSB levy. We welcome this. On the other hand, the registration mechanism will be abolished. It's not our major concern whether 50 cents will be charged. Our concern is on the scheme itself, whether the good habit or good practice so cultivated in the first stage will be destroyed. And I'd like to state my position. I really can't agree on it, even though we agree to part of the scheme, and that's my position for the administration's reference. Anyone else? Dr. Helena Wong. Sorry, speaker's not coming through. Sorry, speaker's not coming through. The legal advice given by the Secretariat to us. The legal advice is that if we have different modes of charging, it should not constitute discrimination as far as this kind of different treatment is concerned. No legal dispute will arise from it. Is that right? That is, if we take this approach in amending the administration's proposal, such that for larger retailers or franchise stores, the levy should go to the administration for the purpose of environmental protection. I'd like to refer Dr. Wong to para 6, Article 22 of the HKBOR and Article 25 of the Basic Law states that everyone should be equal before the law. They have to do with personal characteristic, and the basis should be the relevance to personal characteristics. As for Mr. Wu Chi-wai's proposed amendment, having heard that, we don't see how the criteria of, for example, retailer having 3 branch stores or more, etc., and the size of or floor area of store will have any contravention of our constitution. We need justifications from the administration for us to consider as a whole whether they think there is this legal concern. I hope this can address Dr. Wong's question. Thank you, legal advisor. On this point, can the administration give us a satisfactory answer? Slide. Thank you, Chairman. On legal advisor's point, I have 2 points to make in my response. First of all, we're talking about a conceptual issue. On whether a requirement or whether a provision is in accordance with our constitution or the basic law, we need to have the actual provision before we make the assessment. And at this stage, Mr. Wu Chi-wai has proposed a conceptual amendment, and at this stage, it's difficult for our council to give a very specific piece of advice. Chairman, we're not talking about concepts. What we are talking about is this. We ask for legal justification to address the concerns raised by our legal advisor. That is justification test and also possible contravention of the basic law. You made all the explanations, and now our legal advisor had countered your argument. So if you think that your argument holds water, you should give us your justification. Otherwise, we're going to support Mr. Wu Chi-wai's amendment. So please use legal justification to address our legal advisor's queries. May I explain my understanding of the legal advisor's point? The paper issued by the Electoral Secretariat in paragraph 4, it states Article 22 of the HKBOR. It provides that all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. And I understand, according to the observation of the legal advisor, preliminarily, if the business turnover, floor area, retail floor area, or number of stores, as suggested by Wu Chi-wai, would be taken into account, they may not have to do with a personal characteristic, and our consideration therefore might not be accurate. However, or any discrimination on any ground such as other status, that's the last bit of the article, and this is our major concern. For the PSB levy scheme, if another line is drawn or another approach is taken by the proposal in another member's proposal, then there is a concern. Let's take Mr. Wu Chi-wai's proposal as an example. On the remittance of levy, if different treatment is given to different categories of retailers, there is a concern. Now, for some sectors, for example, for supermarkets, they usually occupy a larger retail floor space, whereas for convenience stores and other stores, they are required to provide statistics that's a different treatment. And for international franchise stores, it's a common approach. Chairman, I think I have to stop him. We ask for legal justifications to address legal advisor's points, but I don't hear any explanation from you. You just read out the same article again. Our legal advisor already makes a point that personal characteristics don't apply to the criteria we mentioned, and you say that we might face legal dispute, and at present you already have different treatment. And in the first place, it only applies to large supermarkets.
If you have introduced across the board levy, then we wouldn't have the second phase. But now you've already started with discriminative treatment. The dual system is there. The dual system is the fact. In the first phase of plastic bag levy, there is the dual system. The question is about this. Please take note of paragraph 2. It seems that the administration says it is unconstitutional, is very dangerous. But in fact, the dual system is there. Secondly, even if there is a difference in treatment, not all difference in treatment is discrimination. Certain criteria have to be fulfilled before you say the different treatment is discrimination. Under certain circumstances, different treatment is acceptable. It's not that different treatment is entirely prohibited. Well, Chairman, let me respond.
個膠袋徵費嚟講，的確好似
On the concerning the first phase, it seems that there is different treatment. We don't deal with every retail outlet. When we introduce the levy, we told the public that that was the first phase. That was a pilot scheme. Our policy intent was and is to extend the levy to all retail outlets. We have a clear policy target. We have sought legal advice, and we were told that the policy intent and the explanation would help to face possible future legal challenge. With regard to a dual system, with regard to different treatment in terms of reporting, we raise our concern, we point out the risk. When there is a specific provision, then we will provide an analysis and give it to members for reference. I think the reply from the DD. And that's in fact what has to be discussed further. Our point is that we don't oppose to the levy, which is a means to discourage people using plastic shopping bags. Our concern is the levy or the revenue from the levy should be used to promote protecting the environment or to encourage using less plastic bags. But there is no such arrangement. The shops will retain the levy. We don't support that. Now you say that small retail outlets will find it very costly to keep records and make reports to you and return the money to you. In order to reduce the cost of compliance, the shops can keep the levy. Now, Mr. Wu of the Democratic Party is of the view that some outlets can do the report, can return the money to you. And you say if that is the case, if requirement is imposed on different retail outlets, that will be very inappropriate. Now you may say, I think the approach should be, say, every retail shop should do the same, but because of cost compliance, the small outlets will be exempted. They will be given a breathing space, and then there will be phase 3 in which they will be covered. You follow the same logic. The levy is for every outlet, is on every outlet, but and also the revenue is for protecting the environment. As for small outlets who cannot comply because of one reason or another, they can be given exemption, but they will have to comply later. And you have to consider what are the criteria for exempting the outlets. If you go along this direction, there will not be any dispute. I thank Ms. Wong for the question or opinion. In fact, we have the same starting point. We want to extend the levy to all outlets in phase 2. This is the ultimate target. We want people to use less plastic bags. We don't aim at increasing the revenue of the administration. We want people to use less plastic bags by the levy. If we extend the levy to most of the retail outlets, that will be helpful in achieving the target. As for implementation, our proposal may be a bit different from Ms. Wong's. In the first phase, large shops were involved. We required them to make records and keep records, and the revenue will have to be returned to the government. In the first phase, about 40 companies and 3,000 outlets. If we extend it to all outlets, that will mean 70,000, 80,000 outlets. The majority, over 90%, are SMEs or even individual businesses. If we require all retailers to keep records like those in the first phase, that may cause difficulties on SMEs. We therefore propose this. In the second phase, there is no need to keep record. There is no need to return the revenue to the government. A retailer distributing a plastic bag will have to charge the consumer. Now, say if a shop doesn't keep record, will there be faking and also will there be abuses? The EPD will conduct undercover inspection, and if a plastic bag is given without imposing a charge, then we can take out prosecution against the retailer. We want to facilitate the retailers. We want to be business friendly, and therefore we make such a proposal. Now, if my understanding is correct, Ms. Wong's suggestion is this. We continue to keep the reporting and also the returning of levy for the big firms. SMEs will be given a chance to accommodate to the arrangement, and then they will be incorporated in the third phase. We believe it will be very difficult, and that is not what we will consider. We want to extend the coverage of the levy, and by making inspections, we try to make the retailers comply. Ms. Wong, you have to wait for the second round. Ms. Sit-Ho and then Mr. Lo Wai-Kwok. Ms. Sit-Ho. Thank you, Chairman. I try to follow the logic of the administration, and I try to find a common point. I've already expressed my concern. We are worried that after you relax the arrangement, there will be relapses. It's difficult to ask a street corner shop to do the reporting and then remit the money to the administration. Let us not touch the small shops and small stores. And following Mr. Lai, the DD's logic, at the end, there is no need to keep record. Therefore, first phase is not unconstitutional because there is an ultimate target. Now, first, I don't agree with him. The more capable should pay more, just like income tax. Mr. Lai may say that's not the right analogy. Profits tax has a standard tax rate, a single tax rate. Well, I just want to tell him that the more capable should pay more, or can pay more. Now, your argument is that since that is the ultimate objective of applying the law to everybody, then the implementation in stages with limited targets is not unconstitutional. Now, if you want to implement it in stages, then can we do it in stages? Instead of 2 stages, Why can't you have 3 stages, just like the government said, just like what the administration says in political reforms? Now, 50 cents. Since as for the 50 cents, they don't need to return the 50 cents per bag. But shouldn't they keep records? It's in stages. It's not in breach of the Constitution because of the final objective, which will be applying the levy to all the outlets. Can you implement it in stages? Now here, we want to stress the point that we can only be more specific in respect of our views when there is the CSA in front of us. The dual system mentioned by Ms. Ho is different from that mentioned by Mr. Wu. Mr. Wu said that shops shop with 3 branches, and then each shop more than 100 square meters. Now the scope will be wider than the 3,000 outlets in the first phase. We really want to know whether the amendment aims at the outlets in the first phase or the other outlets. Will there be a different definition for large retailers? As for the legal point, there are 2 things to consider. Concerning the 2 provisions in our Constitution, are they applicable to our present discussion? The test is different treatment. Our attitude is that the 2 provisions are applicable in respect of different treatment. Concerning the, we can comment more on the view of the legal advisor, but the members' suggestion is we have to consider whether they do comply with the Constitution. Now, I've heard Mr. Lai's view, and I hope members will pay attention to this. Whether it is Article 22 of the BORO or whether it is Article 25 of the Basic Law, they are about the constitutional basis. Even if we grant the administration's argument, even if they are constitutional issues, up till now, the administration has not given us a legal analysis to support their argument. If you look at CB 1432-1314 bracket 01, paragraph 8, or starting from paragraph 7, the administration has started to comment on Mr. Wu Chi-wai. And in fact, the arguments are rather broad or general. Now, by Paragraph 8, by imposing certain compliance requirements on big retailers only, the big retailers would arguably be treated as less favorably than other small retailers, and any such difference in treatment may be criticized as being unfair. I want the administration to explain to members what is the legal basis for being criticized as being unfair, not in terms of policy, not in terms of the general impression of fairness, but on a point of law. I hope the administration can respond and tell us the legal basis so that members can consider their arguments.
Yes, administration chairman. Our response to the legal advisor's paper. Well, it's issued at the same time yesterday. So actually, we didn't cross-reference the legal advisor's paper. We just stated, respectively, our own positions. Perhaps we can discuss with the Department of Justice on formulating a detailed response to the legal advisor's comment. I can give a brief conclusion at this stage, or brief comment at this stage. The administration should incorporate and consider our views. We are concerned about two legal issues on dual system and on different treatment, whether it will be regarded as discrimination on grounds of a personal characteristic. The administration's position is that as long as there is different treatment, it will constitute discrimination. It seems that the administration has, at the outset, rejected Mr. Wu Chiwai's proposal as infeasible, and legal advisor hold differing views, and that is why we need clarification. And we understand that we all need to abide by the law, which is not, we must not just have all the talks about the basic law. What we want is for the administration to give us legitimate and correct legal justifications. To avoid misleading the Bills Committee. So, at this stage, we are asking for legitimate justification for asking members not to consider implementing such arrangements on the grounds of discrimination. Policy-wise, of course, we can have different positions. We can propose different treatments. I think it's too early to put forward such legal justifications that are yet to be founded. And please allow other members who have not spoken to speak first. Very brief, Mr. Ho. Oh, I don't need to wait for the administration's answer. Policy objective, I think that's what we need to agree on. That's to reduce the use of plastic bags. And in achieving this objective, we need to follow up on whether the use of PSBs has increased after the passing of the bill. And this is a concern shared by all. And as to how we can monitor this, the administration has refused the proposal on the grounds of possible contravention of the basic law. What about the operational issue? What is the view on the ultimate objective? Or would it be done by phases? I disagree with you. According to your logic, I hope the administration would go back and reconsider it. Mr. Wu Chiwai has proposed one approach. I think his policy objective is the same. That is, there must be a record of the quantity used. So don't tell me that we're talking about different things. Technical details may be different, but we share the same objective and the same goal. Can the administration try to propose an amendment in order to achieve this common objective? No need to answer. Dr. Lower Kwok. On the point discussed just now at previous meetings of the Bills Committee, I expressed my view as well as the views of the sector. We support the extension of the PSB levy scheme to territory-wide because of the success achieved in the first phase. And why are we regarding it as a success? For the original levy estimated and the 20 million collected in the end, we can see that the scheme serves its educational purpose. And on the extension of the scheme, at that time we already had a discussion on the future direction. For our first step is to impose levy on use of PSBs in larger but fewer in number retailers, and flat top bags, and the scope will be expanded to cover flat top bags, and the scheme will be extended to smaller retailers. And if you ask them to make records, I don't think it's possible. I consider it a different treatment. I also think that setting aside the constitutional issues, the basic law, etc., setting aside the points in law, I think as a matter of reasoning, it's not possible. And I think that the Hong Kong people have a stronger sense of environmental protection now. Whether somebody would plug the loophole, I think it's beyond imagination that somebody would try to plug the loophole by stuffing a customer, stuffing a plastic bag to customer. I express my view. I don't think it's necessary to implement a different treatment, and it's difficult to draw the line. Some said the line should be drawn according to the number of branch stores or retail outlets, or the number of or the floor area. In a capitalist society in Hong Kong, I think it's very abnormal to have such a different treatment. Some ask why this could be done in the first phase. Now, I take the first phase as an experiment. It's a pilot scheme for those retailers who succeeded in the scheme. They should continue to make records and remit the money to the government. Some ask whether the levy should be used for environmental protection. Of course, we must deploy more resources to protect the environment. On different occasions, on different issues, we expressed a lot of views on how the environment protection work can be enhanced. And carrot and stick approach should be taken, and there should be more emphasis on the carrot part. And it might not be necessary to enhance the PSB levy scheme in order to achieve this purpose. We're not setting up a dedicated fund under the scheme for the dedicated purpose. I agree, on the one hand, that the administration should adopt a carrot and stick approach, but on the other hand, I question whether we really need the $20 million collected as levy to be used for environmental protection purposes. Mr. Wong Ting Kwong. Mr. Wu Chi-wai proposed a dual system in this bill, and it never occurred to me that discrimination and unconstitutionality and different treatment in a capitalist society would stem from the bill. I originally didn't want to speak on it, but now I'd like to respond briefly. If levy is charged at the import level, this will exactly resolve all the issues raised by Mr. Wu Chi-wai, Ms. Sid Ho, Dr. Helena Wong, etc., etc. It can also address the concern of the use of PSBs on our environment. We can enhance our environmental protection initiatives by doing so, by imposing levy at the import level. we can address the issue of different treatment for large retailers and smaller retailers. I see that it's very controversial. There is a heated debate on the criterion or the criteria, and if we do that, we can address the difficulties faced by large enterprises, small, medium, small, even micro enterprises on operation of the matter. And we can set up a dedicated fund for specifically environmental protection purposes. And if levy is charged at an export level, individual vendors or micro-enterprises might, in order to have better relations with its customers, decide not to collect levy or charge from the customers. And because of that, they might inadvertently caught by your undercover agent. And we can resolve the problem. Finally, if levy is imposed at the import level, enforcement action will be feasible. Just like the Tobacco Control Office on the 10th floor, there is smoke all around, but no enforcement action can be taken. Should we use government resources in this manner? So I suggest you scrap this bill and think afresh. Go back and think about it. I don't think Deputy Director can answer my question. I'm speaking from the bottom of my heart. Well, he thinks that with different officials, the administration might have a new way of thinking. Mr. Lai, on the feasibility of enforcement action, of course, I will take on board Mr. Wong Ting-kwang's suggestion. It's easy to just monitor the use of plastic bags by these several thousand importers. However, the government's position is this: the purpose of the PSB levy scheme is not just to collect levy. It's just a small gesture, but we try to change consumers' behavior by imposing the levy scheme. Why is it that the use of plastic bags reduced by up to 90% in the first phase of the scheme? That this serves us a very good reminder. If it's up to customers to choose whether to use a plastic bag or how many plastic bags should they get, it's very good. It's a very good initiative for raising awareness, and this is how we achieve the policy objective. We understand that it's difficult to implement it at the level of retailers. We understand that there are thousands of retailers.
We can't ask a newspaper store uncle to have a registration system. When a customer asks for a plastic bag, you have to keep a record. After the extension, the record-keeping system cannot be effective. The principle is anyone obtaining a plastic bag from a retail outlet has to pay for that. If somebody doesn't pay, then we'll take enforcement action. If we know it, of course. In fact, we have common points. We want to protect the environment. We want less use of plastic bags. As I think Ms. Ho's concern is that without the reporting system, you don't know the outcome of the scheme. But there are administrative means to deal with that. We don't need to trouble the retailers. Mr. Chairman, is he answering my question or Ms. Ho's question? Well, I answered the questions of all members. Well, in fact, he has dodged my question. Well, there is no different treatment given to members by government officials. Chairman, I have a follow-up. Now, the Deputy Director said that they aimed at difficult things instead of going down the easy route. Well, I really appreciate that. What is your objective? You better step up education and publicity. Now, the administration doesn't want that 50 cents per bag badly. Now, we have to consider the behavior of the people. We have to consider the mindset of the people. And if there is something that can regulate their behavior, that is good. And you are concerned about the cost of compliance among the SMEs. Well, at the import level, it is very easy to impose the levy on the types of plastic bags. The categories are clear, the numbers are clear, then characteristics are very clear. If you have a piece of legislation, you have to enforce it. Otherwise, you're stupid. What's the point of legislating? If you can't enforce, or if you fail to enforce, if you don't like to enforce, that's just perfunctory. Now you say you aim at the difficult, but it's not convincing. I've said what I intend to say. Whether you answer me or not, I don't care. Mr. Lai, you've heard it. Mr. Wong has been consistent. And I thank members for introducing some humor into the discussion. Ms. Wong, concerning this legal point, the administration says that it will go back and then produce a supplementary paper. We welcome pursuing the discussion. Whether it is the CSAs to be moved by the amendments, but by the administration, or the CSAs to be moved by members, we do need to have suitable criteria to assess those CSAs. We need to be very careful in scrutinizing the CSAs, in particular when the issue of the basic law is raised. Ms. Helena Wong, according to the administration's documents, paragraphs 8 and 9 do not stand because in the first phase there is different treatment already. Mr. Wong Ting Kwong asked for overthrowing the whole system. Now you want to change behavior. That's why you aim at the difficult. I understand your point. But in the second phase, we don't want the merits of the first phase, including the 40 big companies which keep records. And you think the money should go back to the revenue. But if you don't want the money to go back to the Treasury, then at least you should keep the records, or they should keep the records. How broad will the second stage be? We want it to be as big as possible, but you want to find a balance. You don't want to trouble the uncles and aunties who run small stores, who are not able to keep proper records. Now you refer to 70,000, 8,000 outlets, 90% or more are SMEs. I want to know what is a more realistic approach in which you can enforce a law instead of a retrogression to not keeping any record at all. Among the 70,000 to 8,000 outlets, can there be further differentiation? You can single out a certain number of outlets which can keep records, and that will enable us to see whether the legislation is able to take effect. And therefore, in the second phase, you still need to exempt those who cannot keep records. Now, number one, in the first phase, there is keeping a record. In the second phase, there is also keeping a record with the inclusion of more outlets, but not all the outlets. And you aim at a final target of keeping records for all. Mr. Wu has made a suggestion, say on the size or on the number of outlets, size of shop space or the number of outlets. Do you have a counter proposal, say for example, to increase number of outlets from 40 companies to how many companies, basing on the standard in the first phase? Then I believe if you follow that direction, then the discussion will be more healthy. Wang Ting-kong is not happy, Democratic Party is not happy, Zitho is not happy. You're doomed because no one will support your bill. I thank Ms. Wong for her suggestion. I thank Ms. Wong also for showing her understanding. We need to balance our environmental objectives with the capability of retailers observing the rules. Chairman, let me explain to members one more point. In the first phase, the administration had no intention to increase its revenue by the levy. We intended to change people's behavior by imposing the levy, i.e., using less plastic bags. There were two elements in the first phase. The 40 big shops covering 3,000 outlets had to do two things. First, keeping records on the number of plastic bags distributed, and then returned the amount of levy to the administration. That was simple, multiplying 50 cents by the number of plastic bags given. We look at the operation of the first phase and the achievement of first phase. Increasing revenue is not our main concern. The record is needed because the government has to get the money back. In order to make sure that they don't cheat, they give all the levy back to the government. They need to keep records. By looking at the records, we know how many plastic bags have been distributed, and that can be compared to the number of plastic bags distributed in the past. In the second phase, we propose to scrap the record-keeping requirement and the returning of the levy to the administration, because we take into account the newspaper stores at the street of the corner or the lady who sells fish balls. Keeping records and returning the money to the government may not be practicable for these small stores. We consider real-life operation of these small companies or enterprises. But this does not undermine the effectiveness of extending plastic bag levy to all outlets, thereby further reducing the use of plastic bags. Without keeping records, without remitting the levy back to the administration, we can still know the outcome of the arrangement. Say, for example, we can look at the landfills, the waste that are dumped in the landfills. We can look at the number of plastic bags or the reduction of number of plastic bags dumped in the landfills. We can also do thematic surveys. We can do sample surveys on the change of behavior among citizens in respect of using plastic bags. So there are administrative arrangements to assess the effectiveness of the scheme. If we keep the reporting, if we expand the coverage a bit, would that be possible, as asked by Ms. Helena Wong? I think there is a difficulty in understanding the outcome of the scheme if we asked for a partial reporting arrangement. In 2009-2010, we used about 4 billion plastic bags. Now the 40% or the 40 shops, 40 big shops or chains accounted for 10 to 20% use of the plastic bags. The 80% of plastic bags are used by given out by other retailers. If we want to know the change in behavior, we should pay attention to the area which is not covered by the scheme. But if we are to understand the distribution of plastic bags, the use of plastic bags for these 60,000 odd outlets, that will be problematic. But the government can work through other administrative means to monitor the use of plastic bags. In particular, how much less plastic bags have been used. Well, in fact, we have had several rounds of discussion. The administration stressed time and again the principle behind the scheme, the nature of Phase 1 and nature of Phase 2. I think today's discussion should be focused on the understanding of the legal point. I hope the administration could be more precise. The administration should also produce the supplementary paper on the legal point as soon as possible. As for the CSAs from the administration and CSAs from members, I think we need some time to prepare for the CSAs and some time to study the CSAs. So I hope Ms. Helena Wong will talk to Mr. Wu Chi-wai and try to produce the CSAs as early as possible. Today, we still have to deal with the CSAs proposed by the administration.
Chairman, we're not going to formulate a more detailed proposal because we're inviting the administration to give us a counter proposal. Just a simple reminder, Mr. Wu Chi-wai at this Bills Committee indicated before that he would move an amendment, and I would like to remind you that through you or through other members of the Democratic Party, please follow up on his suggestion as to whether there is any counter proposal from the administration so far. Perhaps the administration can indicate whether they are or are not going to give a counter proposal on a dual system or on the requirement for some of the retailers under the extended levy scheme to keep the record keeping system. We're not going to change our position. Then the Democratic Party is also against the across the board approach, and I'd like to ask members to refer to themselves to CB Record 1432/1314 Record 01. From paragraphs 7 to 15, our discussion just now touched upon Mr. Wu Chi-wai's preliminary proposal and the administration's response. I think for the remaining time of the meeting, we should focus on the administration CSAs. There are 4 of them. So over to you, administration. Please walk us through the 4 sets of CSAs. Let's go through them one by one. Mr. Lai. Chairman, if I may be permitted to explain to members the purpose or the direction of moving such or proposing such amendments, so that on each set we can walk members through the relevant provisions in the amendment. I think again in the 3rd and the 4th set we're going to foresee legal arguments. So the overall picture, please. We propose 4 sets of CSAs. In para 2, the first set at Annex A aims to amend the relevant provisions taking into account the valuable comments expressed by members. We think that the provisions will become smoother and they will also become more effective. For foodstuff already contained in airtight packaging, we're going to amend the provisions in this relation. As for chilled or frozen food item, in the first set of CSAs, we have also set out our proposed amendment as in Annex A. The second set is simpler. That's in Annex B. The provision makes reference to the company's ordinance, and as members are aware, the company's ordinance have been amended. So the amendment bill clause 4 in there, cap 32 will be revised at cap 622. So that's just a corresponding and substantial reflection of the amendment. Para 4 refers to Annex C. We would like to, in relation to specific enforcement details, prescribe the requirements through the schedules in this bill. When we formulated the last bill on PSP levy scheme, it was a 2-step mechanism. After the primary legislation was passed, we then prepared subsidiary legislation on, for example, commencement date and the penalties involved and the form of fixed penalty notices, and we waited for the primary legislation to be passed before we considered these. And I think on this occasion, these are more technical matters, and if these information is included in the primary legislation, it will save the time and procedure required for subsequent negative vetting by LegCo, so that for people who would like to protect the environment, things could be expedited. The 4th set has to do with the commencement date. And our proposal is that when LegCo passes a bill, we need roughly 12 months preparation time to implement the details. So the commencement date should be around 12 months after passing of the bill. And the commencement date will also be stipulated in the bill. So these are the 4 sets of CSAs. I'm happy to take questions from members. If there are no questions, we can walk through the provisions one by one. I hope members would note that for the first and second sets of CSAs, the first set has to do with drafting, how the meaning could be reflected more accurately. The second part has to do with an amendment to the company's ordinance, or to the reference to the company's ordinance. The third and the fourth set are more complex. At this Bills Committee meeting, we have never discussed in great depth these 2 areas. We only received the provisions yesterday. On transitional arrangements, again, this is quite new. We received it only today, so I'd like members to take note of these matters. These are the issues to be dealt with by the Bills Committee. We have a huge number of forms and schedule, etc. As Mr. Lai said just now, they are proposed to be put in the primary legislation for saving time. But will it be against our scrutiny procedure? Should members consider whether it should be dealt with by this committee or not? I'll ask the administration to speak first. Yes, please walk us through the 4 sets of CSAs, starting with the first one, and then, if necessary, I will supplement. So if members agree, I will now invite the administration to walk us through the 4 sets of CSAs. Annex A, on exemption of food items, we have considered the view and taken on board members' view on the exemption. We have added 2 items. One is items in a frozen or chilled stage that transpired in the later stage of the deliberation. And having discussed last time, we're going to incorporate this item. And legal advisor mentioned exceptions to exceptions in the drafting of the bill, and we revised it at the same time as in Annex A. So, on Annex A, bracket 4, a question for the administration, D1. Perhaps the administration should explain this. Now, the proposed amendment is a bag that contains an item of food or drink or medicine for human or animal consumption where 1. The item is in a frozen or chilled state. That's in Chinese. In a frozen or chilled state. If we look at the English version, it's written in this manner. The item is in a frozen or chilled stage. So, first of all, I'd like the administration to explain this point. The item in question, be it food, drink, or medicine, at the time of its purchase, it is in a frozen state or chilled state, and it should be kept in a frozen, chilled, or chilled state. Is that what the administration means? Or, regardless of the point in time, it should be in a frozen or chilled stage, and the change of status is allowed For example, it might be purchased as a frozen item at first, but as temperature goes up, it's no longer in a frozen state. Mr. Lai, it's an exemption clause. We need to consider our approach, and in the primary legislation, in the main provision, it states that unless exempted, levy should be, or charge should be collected on the plastic shopping bags, and these are the exempted items. So a follow-up question for the administration. There are circumstances in which the item is originally in a frozen or chilled state, but there is no need to keep it in a frozen or chilled state. So just one example, a sandwich. It might be kept in a refrigerator in a chilled state, and the bag, a bag is used to carry the sandwich. So originally the sandwich is in a chilled state, but as temperature goes up, there is no condensation, and it can be kept at any other temperature other than the chilled state. So perhaps a retailer might decide to keep an item in a chilled state so that it can be contained in a bag for customers to take away. This provision was discussed at the last meeting. We gave an example of a can of Coke. It's contained in a Coke. There is no contained in a can. There is no hygiene consideration. And according to this provision, since it's in a chilled state, it should be exempted. However, after discussion, members were of the view that there is no, it is unlikely to be abused. And I think legal advisors' example theoretically should hold water, but then we don't think it will happen in reality. And the item in a frozen or chilled state should have nothing to do with the food packaging. Well, that's my understanding. Therefore, I'm asking the administration whether they would consider imposing other conditions. For example, whether the item should be or is required to be kept in a continuously frozen or chilled state for it to be exempted under the scheme, or should it just go under bracket 4? If it's no longer in a frozen or chilled state, the quality of the item might deteriorate, so that we know how this provision is applied. Yes, Chairman, perhaps I can supplement some information. Our provision targets condensation water droplets formed from frozen and chilled item, and that is why we allow retailers to give bags to customers without collecting any fees. As for items that is perishable, we have another provision. Depending on members' positions, if we put in the provision for how long the item has been kept in the refrigerator, etc., I think the cashier may find it hard in making certain judgments in this regard. So the way the drafting is done should not be based on the judgment of a person who has no control over an item before it's presented, or who has no idea of the state of the item before it's presented. We think that it's too stringent. I understand that I'm not asking the administration to state for how long the items should have been kept in the refrigerator, but I'm suggesting that it should be explained in greater detail as far as the provision is concerned, and I'm asking the administration to explain what in a frozen or chilled state is meant. As explained just now, it's in that state.
Okay, please go on. Annex B is just a simple amendment. It's just to update the new company's ordinance. It was cap 33 and the new numbering is cap 622. Just a change in numbering. Okay, please go on. And then Annex C and Annex C. The two are related. In our original bill, the effective date is to be, our commencement date is to be notified. And we will deal with the regulation after, or rather, we will deal with it after the bill is enacted into law. There was discussion on whether the levy could be used for environmental protection. We don't know the commencement date, and therefore there are difficulties of making preparation in respect of promotion and publicity. We therefore want to set a specific date, whether it's 12 months or how many months. We can therefore have a work target. And within that period of time, the Bureau and also the community can prepare for that. So this is a change in our work plan. As for Annex C, the amendment, it is to make provision for the amendment of the subsidiary legislation. At present, the subsidiary legislation is in respect of making reports, making registration, remitting the levy, so on and so forth. These are related to administrative arrangements. They are no longer applicable in our new proposal, so they will be repealed altogether. And as for the new regulation, there will be 4 statutory forms for the fines, and they will be included in the regulations. Annex D deals with the savings. The 3,000 odd outlets in the first phase will continue to charge levy until the new law comes into effect. Afterwards, they still have to give the last round of reports and also the last round of levy back to the administration. That is to be done after the new law has come into effect, and we need to provide for that. And this is done by making reference to the first phase. What sort of information they have to provide, how they can remit the levy, and if they don't do so, what will be the penalties. Thank you, Chairman. Please take note that parts 3 and 4 are more detailed provisions for the operational arrangements. At the start, I asked members to take note of these additional requirements and whether that should be added when we discuss the bill. I've already expressed my view. Maybe our legal advisor can comment on that. That is related to Cap 603, the principal ordinance. Thank you, Chairman. I want to clarify certain points with the administration. As said by the Chairman, we only received the CSAs yesterday afternoon. I may have to look into that in greater detail. Yes, please go on. I've heard the legal advisor that she only received that yesterday afternoon. Yes, we did the same. At another meeting, at another committee, we said that the LegCo asked the administration to provide the documents 2 clear working days before the meeting, so that the Secretariat and the legal advisor in particular can have adequate time to look at the legal views or legal points and provide legal advice to us. At another meeting of a bills committee, it seems it's the same bureau, the Environment Bureau. Probably you are too busy. You gave us the paper yesterday. We didn't have time to read the paper. As for me, if you if I received the paper yesterday, or what is your exact proposal? At the start, I've already said that we still have to deal with it. But I don't intend to deal with all problems. But we should make good use of our time. We should raise the issue with the administration. I agree with you. We need some time to study the paper. I therefore suggest that we don't need to look at the CSAs today. They follow the same same approach. Say a certain part is deleted, a certain part is added. In fact, we need a markup copy. The legal advisor has to have some time to look at everything. They say delete 4A and then add 5C. We don't know what 4A is. Now, since this is not by negative vetting, we can have some time to study the CSAs. Chairman, shouldn't you raise it at the House Committee? It's really common recently for the administration to deliver the documents to us at the 11th hour. Shouldn't the House Chairman raise the issue with the CSOA to observe the 2-day rule, so that we can be prepared for the meeting? Thank you, Ms. Ho. I believe all LegCo members do agree with this point. In fact, the administration has agreed, and they should do their best. They try to speed up the process, but you shouldn't expect us to go through the motions. I just say we look at the principles behind the CSAs. But as for the details, in view of the response of members and possible CSAs by members, the administration should have the administration will have to think about it. And we also have the constitutional issues to be dealt with. And maybe the administration also want to hear the questions from our legal advisors. I think we can deal with the principles in respect of parts 3 and 4. I don't rule out Ms. Ho's view. We take note of her view. And I will urge the House Committee Chairman and Vice Chairman to reflect the view to the CSRA. Chairman, I have nothing against officials attending today's meeting. I know that the Environment Bureau is very busy. It has a lot of work to do in the coming 1 or 2 years. In fact, in speaking to the FS on budget, I asked him to increase the manpower, the establishment of the civil service. I meet Mr. Lai 5 times a week and 4 times Mr. Mok 4 times a week. Please don't take it personal. But we need to observe the principle that we need adequate time. We need to have adequate time. Yes, there is nothing personal. Concerning parts 3 and 4, what is the preliminary response of the legal advisor? Legal advisor, please. I want to focus your attention on Part C, Annex C. Part 3, Annex C. This is to amend Cap 603 Subleg A. Generally speaking, they will repeal the requirements for the provisions for registration and recording. They are the compliance provisions, so to speak. And at the end, they will add Part 6, the notices and certificates. And then forms 1 to 4, I believe. They will be dealt with here. Concerning these forms 1 to 4, will they be added to Cap 603A? Concerning these forms, they are to deal with fixed penalty offences. And then if there are such offences and if they take action, then they will fill in the forms. Will the administration explain to members why it has decided to put Part 6 and these forms to Subleg A? All along, Cap 603A is for registration, obtaining information, making records, and dealing with levies. The amendments here are not related to registration, the registration, making records, keeping records, not keeping records, or dealing with levies. The forms are specifically for fixed penalty. And all along, fixed penalty is nothing under Subleg A. Why the administration has made such a change? And then I will supplement my comments later. First of all, I'd like to apologize to members. We issued the paper late yesterday, and in the future, we tried our best to issue the documents as soon as possible, as early as possible, so that we can have a more fruitful discussion. Concerning the observation made by the legal advisor, the forms which have not appeared before, provisions which have not appeared before, are now put in the amendment. In the first phase of the PSB levy, we enact the framework into law, and then through 603A, we spell out the details, say, of keeping records and remitting levies, so on and so forth. Last time, we worked through two pieces of legislation which require positive vetting in order to implement the levy.
Well, this time, in fact, there are two approaches to take. The first approach is to follow the original practice as in the bill. We just passed the legislation for the second phase as the framework. We will then table another piece of legislation for scrutiny by LegCo. That is one approach, but we don't prefer this approach because the implementation details are relatively simpler. Because our idea is that retailers don't need to make registration anymore, and if a retailer is contravening the law, a notice will be issued to the retailer. So the procedure is simplified. On the less controversial procedures and the matters contained in schedules, we'd like to include this in this bill so as to save members' time in scrutinizing the bill. At the same time, members can also have a full picture of the legal framework as well as the implementation details. And if we finish it in one go, it will be conducive to our education and publicity effort, because the details are all contained in the same bill, so it's clear for retailers as well as consumers. When the second phase will be implemented, it will be more effective as far as our publicity effort is concerned. Last time, after passing the bill, of course, we could start our education and publicity for retailers, and then frequently we face the question of when the law will came into effect, and we couldn't answer because we still needed to wait for the electoral scrutiny of the subsidiary legislation. So we hope to finalize the implementation details as well as the framework at the same time, together with the commencement date, so as to, on the one hand, facilitate members' scrutiny work, and also, on the other hand, to facilitate our publicity effort. And that's why we have this change. So may I explain further? I ask this question because I wonder why we're not amending Cap 603, the main legislation, instead of 603A. I hope the administration could discuss with us. We understand that this is an amendment bill, so as long as it's within the framework, whatever approach is okay. However, in the future, for forms or subsidiary legislation, if they are to be amended, by then we may have to refer to the empowering provisions and the details before we know the way to amend them. And 603A, as I understand it, have to do with regulations. And if I'm correct in this regard, according to Section 5 of the of Cap 603, the relevant authority is empowered to make regulations. In fact, under Section 5, it also states that regulations refer to the regulations enacted under Section 29. And Section 29 states that the Secretary may, having consulted the ACE, make regulations, for example, on abolishing registration requirements as in Section 19, and also exemptions, and on remittance of fees and other record-keeping matters. And the administration is intended to do away with this requirement, and also other requirements under this part. And I think this part refers to Part 5, containing the empowering provisions. So it seems to me that for fixed penalty notices and forms and demand notices, and remittance of fees, I think these are matters dealt with. It has nothing to do with the general matters to be dealt with under 603A. So my question is whether it should be put under the main legislation 603 or the 603A, or whether we should follow the positive or negative vetting in future. Please inform members of these matters so that we have a basis for our discussion. Mr. Lai, any response at this stage? Mr. Lai, my colleague, can explain about our specific considerations. I'd like to apologize to the committee, meanwhile, because originally we thought or we intended to make use of two pieces of legislation to extend the scheme. However, we recently reviewed the situation. If we can incorporate the less controversial issues and simpler issues into this bill in one go, I understand that this is a new concept new to members today, and we welcome views. Of course, do you think that this approach has the pros I mentioned, or is it acceptable by members? If so, or if there are other advantages, then in relation to the technical provisions, we can carry on with our discussion. And I'll defer to Mr. Lai, my colleague, to give you a preliminary response to the issues raised. CAP 603A. Is mainly to do with the issue being discussed. But the fixed penalty system is new in this bill, and at the time when 603 was scrutinized, there had not been any consideration on the fixed penalty system. So in deciding which piece of legislation should come under, I'll defer to the Senior Government Counsel, Ms. Lau. Section 16. In fact, amends Section 29 of CAP 603. Section 19 stipulates that the Secretary is empowered to make regulations. May I repeat? Section 29 stipulates that, and according to Section 29, the Secretary has made this regulation CAP 603A, and we are amending the legislation to add a few provisions on fixed penalty notices, demand notices, etc. And this is the scope of our amendment to CAP 603A. So as far as the legal basis is concerned, I hope I can address the legal advisor's question. Did I get the question correctly? Can the administration repeat the last bit of the reply in relation to the amendments? And the blue bill is 3964 in the Chinese version and 965 in the English version. We're amending Section 29. That is, the Secretary is empowered to make regulations in relation to fixed penalty notices, demand notices, and certificates. And Annex C contains provisions in this regard. So, according to the basis you mentioned, 603A, which contains compliance provisions, will be done away with, and what remains will be that the director may specify forms and Section 2 unless otherwise required, etc. Only this bit will remain. That's roughly the picture. So I'd like the administration to explain to members as well. After it goes under Cap 603A, how will members scrutinize these forms in the future, and in what manner? Chairman, this piece of legislation is regarded as regulations as mentioned in the Section 29. So the vetting process will be the same. That is, in order to make amendments, the ACE should be consulted first, and also it must go through LegCo by way of positive resolution. The forms as well, because it's part of Cap 603, so the same procedure applies. Even though it's included here in this bill, well, please don't mind me saying this, but some might be concerned that you are trying to make a shortcut to circumvent the LegCo. I think we should allow the legal advisors some time, as well as some time for members to consider whether we should scrutinize this part, because as mentioned by the administration, originally these two things should be separate, but now is combined. Having considered the time for implementation, etc., and they'd like this Bills Committee to scrutinize the content in the second stage amendment in one go. So the question is whether we should scrutinize more carefully. We don't want to miss out anything. So I hope members will understand what we're trying to deal with. The second thing is whether it's necessary to consult all members, or to ask members to note this new arrangements. We don't have many members here because we are expected to deal with something more than we originally expected. Any questions, Dr. Helena Wong? Form 1, fixed penalty, $2,000. Is it that on inspection, if a person is discovered giving away a plastic bag without imposing any charge, a fixed penalty ticket will be issued? Will there be any chance given in the form of warning? In the Trade Descriptions Ordinance, there is a provision. During custom officers' inspection, in the event of any misrepresentation or breach of the law, an advisory letter or a warning letter will be issued first before fine will be imposed. So does it mean that no chance is given on being caught? One will be fined $2,000.
Mr. Lai, that's what's mentioned in the principal ordinance. As for some cases which are rather straightforward, they can be dealt with by fixed penalty. I think the point raised by Ms. Helena Wong, according to the ordinance, there is no arrangement for giving a warning first. The fixed penalty approach is based on tobacco control and also switching off idling engines. The expansion of the plastic bag levy is to change people's behavior. Publicity and education is very important. but according to the ordinance, there is no warning required. Chairman, next time when they come, I suggest they should introduce the arrangement of giving a warning first. I don't know how much resources you are going to devote to publicity to make everybody knows. I think like catching hawkers, people may get injured because of the cards and also the spilling of hot oil. There are a lot of conflicts. Now, if you don't have the warning system, you may find issuing the penalty tickets very difficult because of possible conflicts. You may say within the first year, a warning will be given if this is your first offense. But after that year of grace period, any breach will be immediately treated with a fixed penalty ticket. Now, since things are done in a hurry, members can give some preliminary opinions. I think we should also give some time to the administration. The administration should tell us what will be the way they enforce the law. Now, she has asked 2 questions. Maybe you don't need to change the law. You can just change your practice in enforcing the law. Whether there is a need to give a grace period, and within the grace period, what will be done and what is allowed and what is not allowed. Yes, Chairman, I've missed one point. Whether the amount should be $2,000. Well, if you get a parking ticket, it's just a few $100. Why you charge $2,000 for the plastic bag? Well, we have limited time. I think there is no AOB, but I just want to remind members, date of next meeting, 17th of December, a Tuesday at 4:30 p.m. Please try your best to attend. Meetings are adjourned. Thank you.